Power does what it wants. Power does what it wants. Power does what it wants.
You hear that, folks? There are two sets of laws. One for the police and one for the ordinary citizen.
Hey guys, Rogue Nation here with you, and today we're going to be going over an arrest, Lucky Laptop News arrest, and his court case. We're going to be looking at the statutes and some case law. None of this is legal advice. This is just me showing how I would go through a case if this was my case. I'm not going to tell you what the outcome of the case may be, or how to apply the specific facts to this case. But we will look at some case law dealing with the statutes in question, and sort of going through what I would do as a hypothetical. So with that being said, let's go ahead and we'll get right into watching the video. Let me maximize this.
How County Internet News. Here was a cop yelling at a kid a while ago. No, I'm not, sir. I got law books. I'm not physically doing nothing. I'm recording you. I am not. You want to take it to federal court? Let's do it. Nope. Freedom of speech, freedom of press. I'm giving you more than 10 feet. I'm a First Amendment auditor, sir. I do this stuff for a living.
All right, let me stop right there real quick and just point out some things if I can. First of all, we're going to notice that this is a two-lane highway here, right? This is a two-lane county highway. This is a public right-of-way right here. Stop that. And you can see right behind the cars where the officer's car is, there's a driveway right here. I don't know if you caught it earlier, but there's a building behind this berm here. You could sort of like see the top over here in the top left. So this is a publicly accessible road here, right? You know, this is not somewhere where we shouldn't be, right? So we're allowed to be here. The next thing I want you to notice is that when Lucky got out of his car, he was narrating to himself, and the officer made the first remark to him, the first part of the interaction. Like Lucky wasn't talking to him or anything of that nature. And that's important when we go through the police report. All right. So officer started talking with him. He didn't start talking with them. And let's rewind that a little bit so you can again see that. Okay.
No, I'm not, sir.
That was the first interaction between the two. The talking beforehand when Lucky had gotten out of the car was just him narrating to his audience, to his video. Okay, so that was the first interaction there, and that was the officer saying that he's interfering with the investigation. Now again, we're on a public road, so you can see the driveway, you can see the building over here. All right, and you can see clearly he's you can't tell now, but we'll watch the officer when he walks toward Lucky. I believe I counted 20 to 22 steps that the officer had to take in order to close the distance in between him and Lucky. So over 10 feet away, 15, 20 feet away easily. So let's continue on.
I got law books. I'm not physically doing nothing. I'm recording you. I am not. You want to take it to federal court? Let's do it. Nope. Freedom of speech, freedom of press. I'm giving you more than 10 feet. I'm a First Amendment auditor, sir. I do this stuff for a living. If you want to call backup, you can. If you want to take it to court, you can. I'll take it to federal court and I will sue you. This is a Constitution-protected activity. casual conversation. You have no authority over me. I haven't broke a law. Babe, get the phone. Get a lawyer.
Come here. That kid was a runaway. A 14-year-old runaway.
It don't matter. Sir, back the fuck up. Back the fuck up, sir.
Oh, you're going to come to my traffic stop and yell at me?
Yes, I am. You're the one that's fucking approaching me.
I'm telling you.
Back the fuck up. I have done nothing illegal here. You are law enforcement, not field enforcement, sir.
Where's your identification?
What for? What crime have I committed?
You have interfered with investigation.
No, I have not. I've got law books.
Where's your driver's license?
I'm not giving you my fucking license. If you don't like it, call your superior right now.
Where's your driver's license?
Call superior.
Give me it right now.
I want your superior.
Now, as we can see from this angle, he's just a couple of feet behind his car.
Hey, get the phone, get a lawyer. Sir, back the fuck up. Back the fuck up, sir.
Oh, you're going to come to my traffic stop and yell at me?
Yes, I am.
Let me tell you something.
I'm
telling you.
Back the fuck up. I have done nothing illegal here. You are law enforcement, not field enforcement, sir.
Where's your identification?
What for? What crime have I committed? No, I have not. I've got law books.
Where's your driver's license?
I'm not giving you my fucking license. If you don't like it, talk to superior right now. Call superior. I want your superior. Hey! Call a lawyer. Call a lawyer. Hey, call a lawyer. Help! Assault! I have broken no law! I'm not interfering. Hey!
Now, we just heard him say that he's under arrest for interfering when he was on top of him, okay? So this is important. And we'll go over the case law and stuff, and we'll let you know about it. Now, before we get into the paperwork and the statutes and the cases, I want to tell you a little bit about his recording. And he uses a laptop to record, okay? And so what he does is he just turns the laptop around so the camera is facing towards whoever he's recording. And whoever is recording, they can see themselves on the screen. Now, when he takes that laptop up, what he's trying to do here, let me rewind it back here. Okay, right back here, and we'll take it as small as we can. So what he's trying to do is he's trying to get his camera up to see the badge number, which from what I understand they wear on their lapel. Okay, and as you saw from his video, when the cop walked up, all you could see was like his stomach. That's because he was holding the laptop down low. And then as the cop got closer and he's right on him now, he's trying to lift the laptop up so he can catch his name and his badge number. Alright, as he brings it up to catch that, the officer smacks that out of his hand. Now, in the paperwork at the beginning, the officer tried to charge him with assault and tried to say that he hit him with his computer. And I've watched this frame by frame, and he does not hit him at all. Those charges ended up getting dropped. There was some other charges about not being as far on the right to the side of the road as possible. And those charges were dropped as well, possibly because him and the lady he pulled over were in the exact same spot. So he probably didn't want to have to give himself and the lady there a ticket. But, okay, now up until this point, he hasn't been told that he's arrested. He hasn't been told that he's being detained. He has been told that the officer thinks that he's interfering. And he's questioning the officer's legal knowledge of that, and he's asking for a superior to be on the scene. As he raises it up, you see the cop knock it out of his hands. there. And then the officer immediately goes to struggling with him. Okay, at this point, he's not been told he's under arrest. Okay, they were on the side of the road. They were, obviously in a heated discussion, but he hasn't told him he's being detained, hasn't told him he was under arrest. Okay, he's told him he's interfering with an investigation, and Lucky knew he wasn't interfering with an investigation, right? We can all see that he wasn't interfering with an investigation. He was far away from him. He didn't speak to the officer until the officer spoke to him. So, as you can see, he throws him on the ground here. And he's not resisting. It's just the officer's having a terrible time trying to get him on the ground because obviously Lucky doesn't want to go face first. So he's, holding himself out so he doesn't get hurt. He's not like kicking the officer or trying to get away. You can see right here, like he's not doing anything. The officer is grabbing his arm. He's trying to turn him over. Then the officer hops on his back and gets him in a chokehold. And then puts his arms behind his back and arrests him. But he's not kicking the officer. He's not fleeing. He's not trying to run away. He's not, swinging at the officer or any of those things. Alright, so we'll get out of here.
I'm not interfering. Hey!
Alright, so that's it for that. Now let's go over to let's go over here to the probable cause statement. It was Trooper Rogers that arrested him. The date was 9/3/2021, so over a year ago. And he said he had probable cause to believe that, okay, we're going to go down there. We don't want to give up his information. He says that he had the probable cause to arrest him for assault, willfully resisting and interfering, peace disturbance, and failure to place vehicle not in motion as near right-hand side of highway is practical. Now, the first charge and the last charge was dismissed, and we'll get to that. Okay, and it says on Friday he was investigating the possibility of a child runaway. And it wasn't a child runaway. What basically had happened is this mother and her kid was in the car, and they stopped on the side of the road, and her 14-year-old, I guess they were in an argument, her 14-year-old got out of the car and was walking away. All right? He said while he was investigating, he observed the gray Chevy arrive on scene. The driver exited the vehicle, approached me, and began to interfere with my investigation. Okay, first of all, again, he didn't approach him. He was over 20 feet away, and he didn't interfere, right? He didn't say nothing at all to you. You started by telling him he was interfering by being over 20 feet away and recording you. He said he arrested him, blah, blah, blah. Okay, so let's get into the narrative here. And I'll leave this up here for a second. You guys can read it. I don't want to read it all, so you guys can pause it and read it for yourself there. And then I'll start where it gets to Lucky. But, okay, he said the juvenile complied and got back in the vehicle. I was getting information from Burke, his mother, when an unidentified man approached me from behind, screaming and yelling. Okay? Now, we all just watched that video, right? No one was screaming and yelling at him. It says, I observed the subject had a holster on his side. Possibly. I don't know. I mean, it's a good possibility. So, I don't think that's illegal, though. And they said holster, not a gun. So, the subject was walking towards me. Actually, the subject had stopped walking towards you. He was staying a considerable distance back. The subject was later identified, blah, blah, blah. He said, I advised he was interfering in the investigation and needed to leave. He continued to scream, appeared belligerent, and was verbally hostile. Burke became nervous, appeared scared, and verbalized she didn't want her kids to be videoed by Fish. I instructed Burke to stay in her vehicle. He approached Fish and instructed him to leave. I again informed him that he was interfering with an investigation, which, again, he wasn't. There was no investigation, first of all. A 14-year-old kid had got out of the car. You told the kid to get back in the car. There's no investigation. There's absolutely no crime there that you were investigating, right? None at all. Like, literally none at all. I also informed Fish if he failed to comply with a lawful request, he would be subject to arrest, right? So, he didn't tell him he was under arrest. He didn't tell him he was detained. He said that if he failed to comply with a lawful request. Well, what's a lawful request? A lawful request is a request that's backed up by law, right? And an officer, as the court has said, is not a law unto themselves, right? Just because something flows out of their mouth doesn't mean that it's lawful, right? So, when you come up to somebody practicing their constitutional rights in the place that they're allowed to be, and you tell them to leave, that's not a constitutional or lawful order, right? It says he became aggressive and hostile and started yelling and cursing louder. I mean, he was, yelling at the officer, cursing at him, but that's fine. That's free speech. It said Fish started to swing his arms and become more aggressive. I didn't see any of this. I saw him lift his laptop up, okay, in order to get a better view of what he was recording. That's it. I didn't see him swinging his arms or becoming more aggressive or any of that stuff. I mean, are we watching the same video? Have these guys seen the video? I don't know, but from the video, none of this stuff is true. It said, while speaking with Fish, he raised his computer above his head quickly in an aggressive manner and struck me with his computer. Oh my God. So this guy literally lied on the police report. Oh, hold on. He didn't strike me because he deflected the strike by quickly grabbing Fish by the left wrist and upper arm. So, did he strike you or did you deflect the strike? I guess it doesn't matter because you dismissed that charge because the DA probably saw the footage and said, yeah, he didn't hit you. Said you forced him on the ground. You gave him several orders to stop resisting. Yeah, we know how you guys like to yell stop resisting so that it makes your narrative seem nice, but from what I could see, he wasn't actively resisting in any way. Maybe he didn't go down on the ground face first like you wanted. You know what I mean? Maybe he put his hands out to like stop him from getting a face full of gravel and grass. But that's not, to me, resisting arrest. Again, not legal advice by any means. But again, I can't see it to be. He maneuvered, got on his back, applied the neck restraint with one arm capture. Said there was a black revolver in the car. Obviously, it was legal. He wasn't charged with anything as far as that goes. Okay, so now we're going to go to right here. And this is going to be the misdemeanor information. All right, so this is going to tell us about the charges that he has. Okay, count 1, peace disturbance, first offense. It says in violation of section 574.010, committed the Class B misdemeanor peace disturbance. The defendant unreasonably and knowingly caused alarm to Rebecca Burke by video recording her and screaming at her during a law enforcement encounter involving her juvenile son. Okay, so right off the bat, he never screamed at her, okay, and the recording of her is totally fine. So I don't think any words were ever directed at her. First of all. Count 2 is a willfully resists. In that on or about September 3rd in the county of Texas, the defendant willfully opposed a member of the Missouri State Highway Patrol in the proper discharge of his duties. That's 43.170. That's his second count. Third count, resisting, interfering with arrest, detention, or stop, 575.150. Alright, and that says a law enforcement officer was making an arrest of the defendant for peace disturbance, and the defendant knew that the officer was making an arrest, and for the purpose of preventing the officer from effecting the arrest, resisted with the arrest by using or threatening the use of violence. Okay, we can obviously see that the one charge is just craziness. You know, just plain out of this world. Okay. So 43.17. This is the let's get a look at it real quick. Count 2. Person willfully resists, opposes a member of the patrol in the proper discharge of their duties. Alright, and here the highlighted part deals with just the highways. And then it goes, any person who willfully fails or refuses to obey such signals or directions, or who willfully resists or opposes a member of the patrol in the proper discharge of his duties, shall be guilty of a misdemeanor, and on conviction thereof shall be punished as provided by law for such offenses, which it's a misdemeanor. Okay. He was not willfully resisting or opposing a member of the patrol in the proper discharge of his duties. Again, he was over 20 feet away. He wasn't yelling at them. He wasn't interfering in any way, as far as, you know, sometimes interference can be verbal. I know a lot of times we say it's physical, and in most instances it is physical. But in some instances, the court has found that interference can be verbal. And one of those instances is when they're talking with a suspect, right? Like what we saw here, he was talking with it. Now, if you were to be yelling at the suspect, you know, don't give him your name, don't give him consent to search, you know, blah, blah, blah. The courts have found that trying to talk with a suspect while they're in the middle of the investigation can be interference. So what I like to do if I'm in a situation like that is I'll narrate. You know what I mean? I'll be like, man, if that was me, I would never let him search my car. Man, if that was me, I would never give him ID. You know what I mean? That's freedom of speech. One is interference, the other is freedom of speech. Right? So, that is this statute right here. Then we go to 575.150. It says a person commits the crime of resisting or interfering with arrest, detention, or stop if knowing that a law enforcement officer is making an arrest. Knowing that he's making an arrest. So we'll go over the case law here for this in just a second. Let Matter of fact, we'll bring that up right now. Okay. And this is a case out of Missouri. This whole case is out of Missouri. This is State v. Jones, 2016. And they say here it is not necessary for the officer to specifically say you are under arrest when the circumstance indicate the officer is attempting an arrest. Okay. In this instance right here, in the Jones case, they convicted him on resisting arrest because he should have known that he was being arrested. The facts of the case are: 1, he had just committed an armed burglary to a house. 2, he was literally running away from the house. 3, the officer saw him and commanded him to stop. Okay, a reasonable person could gather from those facts that, yes, you're probably being arrested. You know, you don't want to be, right? You're like, damn, I got caught. I don't want to be arrested. But the facts are is that you were probably knowledgeable to the fact that that officer was going to arrest you. If he was next to you, you would be under arrest, right? So he ended up failing on this case. But in a situation where, you know, you're not running from a crime, you know, when you haven't committed a crime that day, when you're doing something that you know is legal and protected, right, then even when an officer says, hey, you know, you're interfering, it's hard to say that you knew that you were going to be arrested. So that it's going to be hard, you know, to pass. Also, I believe that, if I'm right, with the charging document here, they say that he resisted arrest by using or threatening the use of violence, right? Obviously, that's untrue. We saw the video. That's not true, right? He didn't once say, you better get off me or I'm going to kick your ass, or, you know, you better stop arresting me or, you know, I'll blast you or something. You know what I mean? So, like, he didn't use or even threaten the use of violence to resist arrest. So, you know, again, and this is how I would go over my cases. You know, if I had gotten these charges, this is the stuff that I would be looking into. You know, the charging documents, the jury instructions on what needs to be proved in order to have this case be adjudicated against me guilty, right? So, okay, so we've gone over 2 of the violations there. Now the first one is 57.010 and 574.010. Now this one has been reported a couple of times as being unconstitutionally overbroad. And here's this. It's peace disturbance. A person commits the offense of peace disturbance if he or she unreasonably and knowingly disturbs or alarms another person or persons by loud noise or offensive language addressed in a face-to-face manner to a specific individual and uttered under circumstances which are likely to produce an immediate violent response from a reasonable recipient, or threatening to commit a felonious act against any person under circumstances which are likely to cause a reasonable person to fear that such threat may be carried out, or D, fighting, or E, creating a noxious and offensive odor. I guess they mean farting? I don't know. That's weird. Yeah, and then number 2 doesn't apply as far as in a public or private place without consent, because it's talking about physically obstructing vehicle pedestrians and egress and ingress to a place. All right, so basically what they're saying is that the defendant unreasonably and knowingly caused alarm to Rebecca Burke by video recording her and screaming at her during a law enforcement encounter. Alright, so we read the statute. Let's go over here to some cases. And this is the state of Missouri versus Robert L. Swoboda. Supreme Court. Started 1983. So you can read through the case. It'll give you like the facts of the case, what had happened. And we go down here and it says, the swearing in question contained the words, motherfucker, cocksucker, and I'm going to knock your damn head off. Defendant does not claim to have communicated any ideology or political thought by his utterance of these unquestionably abusive words. His words are among the lewd and obscene, profane words that have been held not to raise any constitutional problems. So, you know, the words that were used in this video should not be considered offensive. You know, not be considered offensive, but not to where it's illegal for him to say what he was saying, right? In its present form, the statute prohibits a person from unreasonably and knowingly causing alarm by means of loud and abusive language. The prescription of abusive language conceivably embraces words that do not, by their very utterance, tend to incite violence. One might easily, unreasonably, and knowingly alarm someone with abusive words and expressions considerably less, whatever, than those spoken by the defendant in this case. The statute as written can encompass virtually any word unreasonably and knowingly uttered at high volume and with high intensity, so long as a complainant is alarmed. Okay, so basically what they said is that, hold on, let me get down to it. It's a pretty interesting case, but although it would be implausible to say that the words used by the defendant are pleasant, desirable, or acceptable to the reasonable addressee, they are by no means uncommon. They have been held to constitute an everyday expression that punctuates everyday street language. And although listeners may find such talk annoying, it is highly doubtful that the government has much of a legitimate interest in punishment of name-calling between parties. So basically what they held is that unless they are fighting words that drive somebody, yeah, here we go. It says that Supreme Court has held that such offensive language can be statutorily prohibited only if it is personally abusive, addressed in a face-to-face manner to a specific individual, and uttered under circumstances such that the words have a direct tendency to cause an immediate violent response by a reasonable recipient, right? So, and that's State versus Swoboda. And see, so what you can do in these cases is once you have the charging document and you have the case number, you can take that case number and then put it into Google Scholar, right, for the case law. So let's go back like we're doing this all over again, right? Let's see what we got here. So we go to Google Scholar, they've got articles, they've got case law. So you put on the case law. You go to select your court. You can do federal courts. You can do, I got Florida courts because I use this a lot for Florida courts. You can select your court. We're going to check Missouri only. We're going to come up here to done. Now we're going to type in the statute number. That's the statute number. What pops up is going to be every case that has that statute in it. See how these all have that statute in it? So now we can go through and we can read what the court has decided in cases where the statute's been used, right? So we can see the reasoning behind how they rule on this statute. And then we can see if our behavior fits, you know, into what their reasoning is for how they, you know, decide these cases on these statutes. So, and I did the same thing for State v. Jones here, as we just typed in the, and yeah, it's going to be a lot of reading, you know, if you want to be familiar with, and, you know, you got to if you're being charged with it, but if you want to know something more about a statute, like how it's applied, what the reasoning is, you know, on how they decide it and what kind of conduct it prohibits, jury instructions are a great way to know, you know, but also typing into Google Scholar the statute number there, and it'll bring up again every case that has that statute number in there. And you can read, you know, and everybody knows these cases don't have the same fact patterns. But you can read and you can understand why these judges decide certain things in certain ways, and it's going to leave you a lot better off. You know, because you're going to get some education on why they rule this way. You know, like within the Jones case, the guy was running from an active crime scene. He saw a cop along the way. The cop told him to stop. I mean, this kind of stuff is kind of almost obvious, but you know, you want to find out what the courts say about it. So that's the video. I wanted to come on and show you guys that, go through the case. Again, whenever you get charges like this, the first thing you want to do is you want to, you know, research the statutes, just the language of the statutes, like the one where it's, you know, willingly, or you know, willful, knowing that officer's making an arrest, and then go from there. And then also, like I said, you know, with the charging document, you've got exactly what they're trying to say that you did. Like with this one, where is it? I think it's this one right here. Yeah, resisted arrest by using or threatening the use of violence. You know, this is their charging document. This is what they're saying that you did. And you know, these kinds of things are easy to refute with evidence like the video camera evidence or what have you not. So, all right, guys, I'm gonna let you go, and we'll see you on the next one. All right, thanks, guys.